Hi, and thank you for joining the Get Local podcast. Without you guys, we would not even be here. So we're so excited that you have decided to join us today in the studio at 864 Sound in Greenville, South Carolina. I have with me today Doug Lineberry. And so I'm going to let Doug talk to us again this morning about some important information. He's going to educate us as business owners today on copyright. Doug, before we get started, tell our audience a little bit about who you are and what you do and how they can reach you.
Thank you, Joanne. It's good to be here today.
Yeah.
I'm an intellectual property attorney. That means if it's a patent, a trademark, copyright, trade secrets, or any of the accoutrement documentation, I can help you with that. Today, like Joanne said, we're going to be talking about copyright. Copyright, Joanne, is one of those things that's sort of the Rodney Dangerfield of intellectual property. It doesn't get enough respect, but it can get you in trouble.
Really?
A lot of people think copyright, they're like, I'm not some sort of poet. I'm not sitting here writing things. Copyright is music. It is video, like our podcast today is going to be protected by copyright. There's going to be an ownership in that. It's probably going to be owned by the company. And it should be. You want your intellectual property, as we talked about in our previous episodes, we want that to be owned by the company. We want an LLC, an S Corp, a C Corp, some sort of corporate entity to own that. But for copyright itself, guys, it's very broad. And it's everything from a sculpture to possibly a house design, to a song, to the lyrics for a song, to the music video that accompanies the song. So there are a lot of different ways that copyright can impact you. We talked about trademarks in a previous section. Well, one thing we always want to be sure of is that when we use an independent contractor or a third-party artist, that when they're doing a trademark design for you, you get an assignment of the copyright as well.
Wow.
And a lot of folks are like, that doesn't make any sense. I hired these guys to do a trademark. What's it got to do with copyright? Understand that when you're using that person, they're an artist and they're creating a work of art, because that's what copyrights protect, is a work of art, a work with a certain modicum of originality. That is a really low bar. A lot of work that is out there, people might think, you can't protect that. You can. Copyright's a really broad protection.
Oh my goodness.
And so for us in the world of like a trademark, not only are you using it for a branding piece, but there's also that artist who created it. You want to make certain that, again, your LLC, your C Corp, your S Corp owns that there's been an assignment from that artist to you. Another big issue we see a lot of, Joanne, is folks don't get that you just can't lift something off the internet. And it's so funny. A lot of my clients who have play music will occasionally get busted for this. BMI or ASCAP, the folks who own the majority of the license for most performing artists, will send out investigators. And they'll go sit at your pub, they'll go sit at your brewery, they'll go sit at your bar, they'll go sit at your outdoor venue, and they'll just sit there and they'll look like me and you, Joanne. You won't be able to spot them. They're going to go in and they'll look like a student.
Having a beer?
It is just having a beer, and they'll be sitting there with their smartphone out, and they're going to be recording the music you're playing. And if you don't have a license, you're going to get back a letter from them saying, hey, we sent an investigator on this date. You've played these songs. You don't have a license to them. What do you do? Well, after you're done panicking and running around a little bit, take a breath, calm down, and realize, hey, I'm going to have to deal with these folks, because copyright is strict liability. Saying I'm sorry and mea culpa still doesn't change the fact that you damaged the artist.
Oh my.
And same for lifting songs, lifting pictures. That's a thing that gets people in trouble all the time, Joanne. If you're out there and you're designing a website or you're doing a newsletter, make certain that you have written permission to use any pictures, any text, anything that you take from another location that you don't create. And you're like, well, that's kind of a common sense rule. And it is, but it's also, we're inundated with an internet that makes it so easy just to cut and paste. And you're like, I need a picture of a forest. Boom, cut and paste. I literally have had clients get cease and desist letters for pictures of a forest that they used in like a newsletter.
Oh my goodness.
We don't want this to happen.
What about social media? Because I think a lot of businesses are not, the owners are not content creators. And so just like you said, maybe they need a forest or a picture of a product. And so they're just going to Google, they're typing it in, pictures popping up, click on photos.
And they take it.
And then they just, they're taking it and they download it and they're using that on all these social media platforms. So if someone catches that, how would they catch that? Would they have to Google it, or is it going to pop up?
It's a great question. And Joanne, a lot of the more sophisticated artists have like programs like robots that will go out and look. And they'll be like, hey, I want you to find this. And they'll find it. No matter how hidden you think it is, no matter how obscure you think your use is, it will be found if they're diligent enough. And so, Joanna, that's an awesome question, because you're like, hey, I've got all these social media platforms. What do I do? Well, remember, each use is a different infringement. And so we want you to, A, not infringe. If you need some sort of background photo, if you need stock photos, go to a website and get a license for those photos. Save that someplace. And again, looking into the camera, save that license. Be certain that you can go back to it. I've had clients get letters for uses that were 5 or 6 years old.
Oh my goodness.
And think on that. How hard is it to find a document from 5 or 6 years ago?
Right.
But you need to be able to for these documents.
Print that, put that in a file somewhere,
Absolutely.
stored electronically on the web, right?
And that way you can turn this on its head and say, hey, I had permission. Here's where I went. Here's what I got. But if you don't have that permission, Joanne, you're negotiating.
Yeah.
And you're trying to figure out, hey, how do I buy myself out of this?
See, I think another area that a business owner may get in trouble is a lot of people are doing lives, particularly on YouTube or Facebook or some of those venues. And a lot of times they're playing music in the background. Now, I know some of the social media platforms are getting a little bit more sophisticated in that they're checking before they post it to see if it's copyrighted.
Yep.
But I wonder how much of that actually may slip through.
The live especially, Joanne, is dangerous, because it's instant. And unless, like you and I don't have a delay,
Right.
we're sitting here, we're talking, here's the podcast, but it's going to go through processing. So there is a delay built into it after the fact. But if you're on a live program with no time delay,
Right.
it's instant danger. You press play on the boombox and bam, here comes, Ice Ice Baby. Guess what? Vanilla Ice might be coming to you for a royalty payment. Because remember, he had to do that. You had Under Pressure with David Bowie, dun, 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 dun. Now, I slaughtered that, but you get it. It's the beginning of both Under Pressure, and it's also a riff in Ice Ice Baby. So that issue came about. Vanilla Ice ended up buying the royalties to Under Pressure so that he could keep Ice Ice Baby without having any problem. He, to this day, still gets a royalty anytime David Bowie's Under Pressure is played on the radio.
Oh, my, wow. Well, and that's kind of like, I'm not to throw out anything controversial, but I was reading the other day, like one of the artists that Trump plays the music for when he goes in was sending him a cease and desist letter. Then it had even passed on. That artist had passed, but his family was receiving the royalties. And so the second song, the family sent him a cease and desist.
Yeah. And Joanne, that is an awesome point to bring up because copyright is the longest lived of intellectual property. Patents, designs 15 years, a utility is going to be 20 years. Trademarks can last a long time. We've talked about Stella Artois, and it's a really old trademark from the 600s. But copyrights can't, again, trademarks have sort of a perpetual life because they're always in use. When a copyright is registered, its initial lifespan is the life of the artist, one of us long-lived human beings, plus 70 years. And there's some other numbers that can matter depending on how the work was created. But think about that. One of us long-lived human beings, we can reach 100 easy. And it's like, hey, that person dies and then there's another 70 years of protection.
Really?
That's why the family reaches out and says, hey, because guess what? It is a property right and it can fall to them. If they didn't assign it to someone else or someone else doesn't own it, the property are the custodians of it. They're the persons who protect it. They're the persons who can enforce who can or can't use it.
Wow. And I know for also social media, one of the big things right now is reels and stories, and it produces a lot of music in there, and it gives you the opportunity to use some music that's already on there. You're okay to do that, right? So if you go to, if you're going to create a reel on, let's say, Instagram, and there's music, you can choose from it. You're okay to use that music.
Make certain. This will be that sort of boring homework thing we do. Make absolutely certain. Notice I'm looking at the camera to enforce this. You want to read the section about, hey, what are our licenses? And if you're using what they've got permission for and you're within the scope of that, just make certain that you're protected, but do not introduce something else that you brought on your own unless you have that license. And again, they're different licenses. Like, the license for a venue that serves 50 people is different than the license of a Madison Square Garden. So you have to be really careful that you're using the right license in the right way. And if you're using these programs, you absolutely want to confirm that if I use whatever you provide me, that I'm okay. Just don't click go and assume you're all right. Do a little homework before you click, hey, let's make something.
And I would say that this rule still stands for even like nonprofits. So churches or a nonprofit who's out there who's, playing a song in the background, or if you're a speaker and you go out, you have to be careful with what you play as you're coming on the stage or going off the stage as well.
You do. And a lot of folks would be like, gosh, why would you go after a church? But it really depends on how aggressive the license holder is. If they're like, look, I only want this to be played, or, what if they're from a different denomination and they don't want it used at that church, there are a lot of reasons that could happen.
Right.
And so you're absolutely right. And I think a lot of people think, hey, I'll get away with it. It's all fun and games until you don't.
That's right.
And then once you don't, it's strict liability. It's like, how much were you damaged? And probably if you're found out, it's one of those that's probably been used a lot, So it's not a very good situation to be in, Joanne, but a really easy way to not be in it is to create your own work. That said, a big issue now is AI. You and I were talking before the program about uses of it. Attorneys have gotten in trouble because an AI created case law that didn't exist. And the attorneys did not check behind, so shame on them. But, you send an AI out there and everybody thinks, oh, it's the AI. It's going to be great. It's awesome. They're a data collector. They go out and they bring in data. They bring in images. They bring in snippets. They bring in text. You have to be very careful using them because if you turn them loose, Joanne, and they go out and bring in some third party's work, whether that's a song, maybe a snippet of a video, maybe some text, you could be liable for that.
Yeah, because there are a lot of AI programs now that will actually design.
Yep.
They'll create a logo for you,
Absolutely,
or they'll create a photo to go with a social media post that you're creating. Now, if you go in there, and I don't know how much you know about AI, but let's say I go into AI and one of these generating programs who will draw up a logo for me, and I say, "Do not copyright another one." Is it gonna copyright it?
I love it, Jim. And that's a clever thing. If you could type it in and be like, "Do not infringe copyright when you make this." Unfortunately, these AI are smart dumb, and you now may have introduced something like infringe a copyright. Oh, well, maybe I should go look at all these other things. And your instruction might actually lead the crazy thing to do it instead. So if there was some fail-safe of please don't infringe a copyright, I would tell you to use that. But really at the end of the day, whatever that product it produces is, you're going to have to do your own check.
Gotcha.
You can't rest on the laurels of, hey, the AI did it and I'm awesome. Because, like with the Get Local one, you've got to check it. You've got to make certain there's nothing that looks like it. And even when you file something at the PTO, they may push back and say there are other marks that do look like it. But if you just run haphazard and say the AI made it and it's all good, that way lies trouble.
Okay. So if I'm going to create my logo, the first thing to do is kind of get it all drawn up, sketched up, before I put it out into the world for everybody to see. I really should come see an attorney. You
should, because the reason, and I know it's an attorney saying use an attorney, Joanne, but the reason we do that is it avoids a lot of trouble. Because let's say you create it, you've got it done, you're like, this is awesome, I love it, I'm going to start using it. You put it on a facade. And again, what if you used a third party to do it and that you didn't get an assignment of the copyright?
Right.
Back to today's message. You go out, you put it on your social media, you wrap a truck, you start putting out flyers, you start sending out, e-invites to folks. And every time you use that logo, a couple things could happen. If it's too close to somebody else, it could be infringement. And if you don't have the assignment of that copyright from the artist, you could be infringing their copyright. So there are a lot of issues on that, Joanne. Not just, hey, I've got the best copyright ever and I'm moving forward. Got to have a safety net. Check and make certain it's clear. Make certain that you fully own it. And I know it sounds silly, but we have a Greenville case right on point about a kennel and the picture of a dog. And sure enough, no copyright assignment was obtained. The artist comes back to the kennel and says, hey, I'm glad you like my work. I need a royalty for this. End of the day, the court sided with the artist and said, yep, this was the artist's work. You did not have permission to use it. You owe them a royalty.
So what if, in that scenario, if they just said, okay, we won't use that anymore? They're still going to have to pay for
That's exactly it. That's exactly it. It's strict liability, Joanne. It means, hey, some damage has been done. We've got to figure out the quotient for that. So, yeah, you could stop the bleeding, but unfortunately, there's still a gallon of blood that's got to be paid for.
So not checking a copyright or getting a copyright could really cost you a lot of money in the long run.
It could. You want to make certain that, hey, and the safest bet is create it yourself or have permission to use it. Just don't fall in those cracks. And a lot of folks, you get busy and you're excited about business and you forget to cross that T or dot that I, but you have to do it because if you don't, Joanne, it could come back to haunt you.
Now, I know there's a lot of sites out there like Pixabay. You can go to, Adobe. So you can go at a lot of those and sometimes they'll charge you $2 or $5. What in that scenario, do you still need to get permission to use it, or do you just need to read what that license is?
Beautiful. You do want to know what that license is, because if you're paying $2 for a license, it's probably not the, hey, you can use this in any way you want. Indeed, some of these licenses may forbid you from using it to create a logo or a trademark. And so you might think, oh, I paid $2 for this image. I've got it. Now I'm going to make a trademark out of it. You may not be able to. You want to read that fine print. Again, I realize it's boring, but if you don't read that fine print, and you go out and have a logo generated from it, it can be void because you may have violated the license originally.
Wow. And I know some of those sites, it'll say you can make a donation. Some sites say you have to give the artist credit for it. So now what would that mean? So let's say if it says you give them credit.
First of all, you really read that fine print, because a lot of people mistakenly believe that, hey, if I use something from somebody and I put their name below it and saying, I got this from John Smith, I'm okay. Literally, you've confessed to infringement if you don't have John Smith's permission to do that. You know, you go grab a picture by John Smith, or you grab a snippet off a webpage from it, and you slap it in your newsletter, and you're like, bye, John Smith. All that does is makes the infringement allegation really easy, because you get back a cease and desist letter that's cut and pasted from your use saying, oh, and by the way, you said you got this from John Smith. So to do that, Joanne, we want to have written permission, either from the program or the site that's providing it, or from the artists themselves. You know, giving them credit, that's awesome, but that's more of a plagiarism issue than an infringement issue. Because if you take it without their permission, that's infringement. And it doesn't matter whether you give them all the credit or not, you're still infringing, because copyright ultimately is the right to make a copy. And unless you have a license, that remains with the author. If you don't have a license, you don't have the right to make a copy.
Gotcha. Now, I've seen some artwork where they'll say you can use it if you use it for free, but you can't sell it.
Can't commercialize it.
Right. Can't commercialize it.
Absolutely.
So if you get that and you wanted to, let's say I get that, and in the beginning, I'm like, I'm not going to really do anything with it. Just use it for a little bit. And then all of a sudden I love it and I want to make that my logo.
Yeah.
What do I do there?
You're going to have to find that artist. You know, we got to go back, because, hey, what is a trademark? It is getting a consumer to buy your goods or services. So it's absolutely for profit. So you want to go back out to that artist and say, hey, I would love to use this. I need to get permission to use it. How much is it going to cost? And if that cost is too high, or if it's too much of an expense, then you might want to just go to the drawing board and come up with something else. But if you really like that work, Joanne, go find that artist and get permission.
Now, a lot of folks too may think, okay, I'm using Fiverr or Fiverr. I'm not sure how they say that, but and those people a lot of them are international. So what's the likelihood? They're probably thinking, oh, they're, in the Philippines, or they're in China and they're Korea. They're not going to come after me. I mean, what is the likelihood? Do you see some of that where international folks are actually coming after their artwork here in the U.S.?
And another beautiful thing about copyrights are they also have the broadest protections. Their copyrights are under the Berne Treaty. Basically, any industrialized country will recognize the other's counterpart copyrights. So yeah, thinking I'm in the U.S. and they're in the Philippines or Japan or China or someplace, that is not a good defense. And, the world's very small. I know we're a cool little blue-green marble, but ultimately, our podcast is going to reach people that we'll never see. And the same thing for your use of intellectual property. It's going to be out there on the internet. It's going to be in social media. It might be copied by somebody else and put somewhere else. You don't know how far it's going to go. And so you have to protect yourself at day one, because using that whole anonymity of, oh, they'll never find me, it's the internet, folks. You look hard enough, you can find whatever you want.
Right. Now, I've also had people ask the question, let's look at our logo, for instance. We've got the little lines in and out on the outline of South Carolina. They say if you take someone's work and you modify it, then it doesn't count as copyright, right or wrong?
I love it, Joanne. I love it. And that's a partial one, because it will depend on, does it look like a derivative? Like if somebody takes the Get Local and all they do is flatten this edge of the South Carolina coast, the side facing the Atlantic, well, big deal. That you can still tell that's the Get Local. You just made it flat on the Atlantic side of it.
Right.
And so, but they might be like, well, I cut out all these curves and I cut out all the bays and look at all these lines I got rid of. But at the end of the day, you're going to be like, that's a derivative work. And so if you want to take and modify somebody's work, go to the source, find that artist, and get their permission to do that. And if you got to pay for a license, pay for a license.
Gotcha. Now, what about, I've also seen business owners do this, where they take artwork from multiple people and merge it into one. So what is that scenario?
Wow. That's called multiple cases of infringement, Joanne. That's awesome. Because let's say you do make I was going to say kaleidoscope, but a collage of works from a group of different people. If you can still identify the work it came from, infringement. And unfortunately, it's not just one piece.
Now
Let's say,
3.
It's 3, it's 6, it's however many you did it. And if you can tell where it came from, like, I don't know if you ever watched WKRP in Cincinnati.
Yes.
Okay, remember where they had the giveaway and you had to listen to all these little snippets of music. And it was none of them were the same song, but it was like Francis Scott's Key, the Star Spangled Banner, and a rock song and some other stuff grouped together. But each one of those, even though they're played in like a single instance of a sound snippet, still has their individual copyright to it. Same for a collage. I mean, it really is something, and not to scare folks, Joanne, but we want them to be aware of it because it's an easy way not to get in trouble.
Right.
It's just to make certain that it's original. Either
Right.
you created it, or if you didn't, you got a license to use it.
Now, tell me a little bit about your process. So I bring, I've drawn up my artwork. I've brought it into you, and I said I want this to be my my logo. So
Yep.
what does your firm do? What
Sure
are y'all
thing.
looking at?
What we can do is do a search of the USPTO, and you can do your own search at home on Bing or Google, whatever system you want to use. But what we will do is look at the marks that are registered at the USPTO. Those are the ones that are going to determine how your application gets through or doesn't get through. And you'll say, hey, I've got an outline of the state of South Carolina. We'll do a search and see what other logos have similar things. And again, yours is a tripart because you've got wording, you've got the design of the heart, and you've also got the stylized South Carolina image. So you'll want to look at all that in conjunction. And that's a really good thing to go and have done early on. Because, if you're using a graphic designer or a design studio or someone, you're going to have some faith in them that, hey, you went out, but it never hurts to ask to say, hey, where did this come from? And if somebody says, yeah, I was staring at this other logo and I thought it was cool, you might want to take a breath for a second and be like, all right, show me what you were looking at. Let's look at mine, because you want to make certain that, you just don't flatten the Atlantic side and are like, new logo, let's rock, because Get Local is going to be all over you for that.
Right, right. And as an owner, once we do have our work copyrighted, whether it's music or like you said, our logo or documents, we really kind of have to look for that ourselves, because there's no copyright police out there
There's
that's
not.
checking, right?
Same for trademarks, same for patents. All of this falls on the owner. And so if you're going to go through the expense of it, you do want to take those steps. You do want to say, hey, this is mine. Because, there's a concept called naked licensing, and it's not nearly as fun as it sounds. It means that you literally let third parties license without any control on it. It's naked, meaning there's no restrictions, there's no requirements, there's no come back to Joanne and ask if I should be doing this or not. You just turn them loose. That can destroy your IP. You've got to be very careful about that. But the onus does fall on the owner. And that's why, it's valuable. You're wanting to protect it. And once you obtain it, you've still got to protect it. You don't want somebody out there doing something with it. Are they using it in a scandalous way? Are they using it for a competitor? There are a lot of ways that you wouldn't want your marks used. And if you find them, you do need to be really quick about tamping those fires out.
Okay. So let's say, one of the things that I always worried about, is we're here in South Carolina, obviously, and someone in Florida is using it.
Sure.
And if they're using your copyrighted information, somebody might think that's your branch down there.
Absolutely,
right?
they could.
It's a location of Get Local.
You will want to reach out. You will want to do some investigation. See what they've been doing, because also make certain that we didn't inadvertently copy somebody else who's older than us. That's kind of the fear too. If you go out there screaming at them, make certain you're not poking a dragon. Maybe that was missed, and we set up a situation to where, hey, we were in South Carolina, but they've been in Florida for 40 years.
Oh my.
So be careful. Like in the trademark realm, they might just turn around and be like, yeah, I'm going to cancel your trademark.
Oh my gosh.
So yeah, there's different ways that can work. So you want to go into it with your powder dry. You want to investigate. And man, if they're younger than you and you can absolutely see that they're like taking things or taking copyright material from your sites or your feeds or whatever it might be, absolutely reach out to them and get them to stop.
So if for copyright, again, back to our logo, you can take bits and pieces of a logo and it still be a copyright.
Absolutely. If you take enough of it to be able to say, hey, this comes from Joanne's Get Local logo, boom, that's infringement. It's a derivative work, and only the copyright owner can do that. Again, right to copy. That's all copyright is a right to copy. If they don't have a license to do that, or if they just try to make the state, like a diamond shape, I've seen people turn it into that, because South Carolina does look a lot like a diamond. And so if they make it into that, but they've got Get Local in the center of it, guess what? It's still too close, So you want to enforce that. You want to stop those uses. You do not want to permit those.
And so what is the time frame? If I'm a new business, I'm getting ready to launch, at what point should I really get with someone to take a look at the copyright?
Well, copyright, trademark, all that before you launch.
Okay.
You want to make certain this is a day one. You want to make certain that you're clean, because if you go out and you've not done that search, Joanne, Lord forbid that we, AI created a logo and we didn't check on it, and it mimics somebody, you can open the gates for the business and get a cease and desist letter almost instantly saying, hey, stop. Get rid of all this stuff. Burn all of the current materials you have. Yeah, and you wouldn't want that. And just an easy quick fix is reach out to an intellectual property attorney. Not the litigators, not the car wreck guys, an intellectual property attorney to say, hey, I'm getting ready to do a business. I want to get a clearance on my IP. Is it okay? And there's things we can do to help.
And I think a lot of people, maybe they don't go anywhere. They just draw up their own, they draw up their own logo.
Yep.
But inadvertently, you could still be close to something that someone else has, right?
You could be. You still want to check,
Yeah.
even if you did it yourself. And human beings are very creative. We're very inventive, but we're also influenced by things we don't realize. Dreams are kind of like your clearinghouse. And if you have a dream about a logo, you might have seen something similar to it. And you're like, oh, this is my logo. But it might have been something subconsciously you liked and didn't realize it, but it comes back out in the dream. So be very careful with that. Even if you create it yourself, you still want to do that same check.
Well, and then you also want to protect it so no one else steals yours.
Absolutely.
Because if it's a great logo or a great piece of work, you don't want someone to steal your piece of work.
Absolutely. Think of the Nike swoosh. Simple, elegant, boom. Superman symbol, the McDonald's arches. All of those in their right are now cultural icons in addition to being a trademark. You look at them and you're like, I get it. I know what that signifies. And so, yes, when you create your own original one, you want to protect it.
And so how long does it take? If I come to you, I'm going to launch in 30 days, could you have it copyrighted in 30 days or is that a longer process?
We can get it on file. Now, we've got to go through the copyright office or the trademark office, depending on what work we do. Copyright, roughly 6 to 8 months to get that one back and registered. A trademark's a little longer than that. Typically, it's going to be 10 months to get back an initial office action and then maybe another 7 or 8 months to get it finalized.
Wow.
And so, but once you're on file, that's the best protection for you. You don't want to delay this thinking, well, I'll do it eventually. Go ahead and get your trademarks on file because guess what? When you file your application, if somebody tries to get local soon or get local now, then guess what? This logo is blocking that mark. It's out there fending it off for you. And you don't even know that. That is one of the sort of benefits of having that application on file early is those that are likely to be confused with it are going to get a rejection in view of it. But that only happens if you file the application at the trademark office.
So if it takes 6 to 8 months, 10 months longer for trademarking, what happens if mine is too similar to something else and I've already produced this and I've already started my business? Is it better to start like even before,
Absolutely.
Much sooner then?
Absolutely. Before you open the doors and start putting product out, you want to make certain you've got a clear trademark, or if there's copyright material to it, you want to make certain that, hey, it's original or I have a license to use it for the purpose I'm going to use it for.
Well, I have one last question for you. What about our listeners who are saying, I've been in business for a year now. I have not copyrighted, trademarked, patent, anything that I have. It's too late.
Okay, that's awesome. That's a great question. That's a hard final question. For a patent, if you've been using that process or that device and you've had it out in public for more than a year, I have some bad news for you. We're going to have to sit down and do a calculus to figure out how we get over your own stuff being your prior art. Whatever your invention is that you put out there for more than a year, that's now what you have to overcome.
Wow.
Trademarks and copyrights, more forgiving. We can go back and file for those, but understand if you've been out there for a year, maybe somebody else had a similar mark. Maybe, you filed your Get Local. Maybe there was another Get Local who didn't do a good search. They've been out there for a year and they're Get Local Khaki. Get Local Khaki, K-A-K-Y, just our abbreviation. And they throw that out there and they didn't do a good search. Well, guess what? When they come to one of me or my ilk, we're going to say, hey, need to make you aware. There's a Get Local mark out there. These guys have got an application filed. If you're going to try to file for this is going to be a problem. And so if you're now the owner kind of getting that rain on your parade, you've got to figure out, hey, do I reach out to Joanne and see if maybe we can coexist somehow and get something in writing to commemorate that? Or do I scrap the lot and start over?
Wow.
But again, you only find that out once you've had these searches done.
So it's never too late. I mean,
No.
even if you've been in business for a while, it's better
Absolutely.
to come on in and talk to
Absolutely.
you
Get that
and
check.
let you guys take a look at it.
I just had a client 2 weeks ago who'd been using a mark for more than 5 years. Luckily they were clean, they were clear, and that's awesome because if you come in and tell me, hey, I've been using something for a long time, it kind of gives me butterflies because I'm like, oh gosh, we're going to have to check this. That one luckily came out clean, but I'm not telling people to wait 5 years. The sooner you do this, the better. Indeed, in a perfect world, you've got that trademark application filed before you open for business.
Now, if you catch it, let's just say, and I said that was the last question, but that took me to another one. Let's say that scenario, that 5 year, and it didn't come back clean. At that point, are you going to have to advise that owner to change whatever he was doing or contact the original copyright to see if he can still use it?
Great question. In it, there is a certain lassitude of, hey, I've been doing it for this long. Does it count? 5 years? Have they seen you and just ignored you? Is the other group still in business? You want to check, because realize your trademark application may have outlived the business. And you might see that there's a trademark out there pending on the trademark office website, but the business may be gone. But, then it could be the situation they just haven't found you yet. And so you've got to make that client aware. And it's sort of a harsh conversation of, you've been using this mark for a while. You've got a lot of love for it. You've got a lot of ingrained value to it now. But there's another mark out there. And let's just say we check them. It's an existing business and they just haven't approached you yet. Maybe you go with the live and let live policy and just see what happens. But as a good counselor, I've got to tell you, there's a possibility that they could come at you and they could be like, hey, you need to stop doing what you're doing.
But they're probably not going to call and say, I've been doing this for 5 years. Is it okay?
Yeah.
It's probably, they're just going to change it, right? In most cases.
You would think about it, and especially depending on the size of the gorilla on the other end of the equation. If it's an 800-pound gorilla and they're known for enforcing things and are very aggressive about it, then you want to start looking at a different avenue. Well,
and I just think there's so many grays that if you're out there trying to do this on your own, like if you're trying to file, and I'm assuming you can file your own.
You can.
But,
if you don't, but I'll tell you this, Joanne, if you don't surf, don't start. Because trademark applications, copyright registration applications, patents, you think you know what you're doing. There's so much nuance. And in the world of patent, comprising, consisting essentially of, those 3 different terms entirely change the scope of the patent. And guess what? If you're just me or you off the street doing it and I'm not an attorney and you're not educated in it, we can make that mistake. Same thing for a trademark. If you go ahead and you fill it out and you're like, I want all these classes, I'm going to make all these goods. You get ready to submit it and it's going to go, okay, you wanted 20 classes, that's $250 a pop. Let's do the rough math. You now owe me $5,000. And that's going to make you throw up in the trash can and be like, wow, how did I do that? So you want to be very careful with that. I always advise you, go to an intellectual property attorney. You will see these places online. They were like, we can do a trademark. We'll do a patent. You want somebody that you can talk to. You want somebody that, hey, if it goes wrong, you've got a bar. Like the South Carolina bar can come and kick me around if I do something dumb. You want that relationship with your attorney. You want the ability to say, hey, let's jump on a Zoom and talk about this thing, let's meet for lunch, whatever it might be. You want that contact. You do not want some sort of anonymous organization handling your IP.
And I'm sure, Doug, our listeners who are business owners would be able to come and have a meeting with you, a consultation. Absolutely. And then, you can sit down and say, this is what I would recommend, the patent, the trademark, the copyright. Here's what your fees would be. Here's the time frame to get that done. And that is worth at least having that consultation.
It is. Don't be afraid of that. Hey, go and call multiple attorneys. You might not like me. You might not like somebody else. Weigh it out. Go with the person who doesn't cause the hackles in your neck to rise. Feel like, hey, I can work with this person. This is good. I want them to take care of my IP.
Well, and we do like you, Doug.
Thank you.
We like your firm a lot. And so, as our preferred attorney, we really recommend all of our business owners talk to you. I think you have been fantastic. You're wonderful in the way that you explain it. To the folks who come in and sit down with you. It's not so much legalese that we're walking out feeling really stupid,
Yeah, that should never be a situation.
I feel like you're really good at advising us, and because Justin and I use you as well for Get Local, and so we really appreciate your firm and all that y'all have done and the education that you give to small businesses.
And I get it from my parents, both were teachers, and if I can educate you on this, it will solve so many problems. And things that might have come up, we'll just avoid them because we're going to do things right at the beginning.
Yeah. Well, I cannot thank you enough for coming on. We've had 3 shows with you, and hopefully we'll get some more information for our business owners. Thank you so much for joining us today.
It's been a pleasure.
Listeners, thank you for joining us. I really appreciate each and every one of you who come and you not only listen, but you like and share. I want to thank Brandon Higginbotham, who is the owner of 864 Sound right here on Sweetbriar Road in Greenville, South Carolina, who produces, edits, and just makes us all look beautiful, both video and audio. If you have any needs at all, video, audio, musical, you need to come see Brandon. He can take care of all those needs for you, and he loves small businesses as well. So come check him out. Thank you again for listening, for joining the Get Local podcast. We'll see you next time. Bye.
Take care.
Bye-bye.